making a film, and I've ended up being a mole, and I'm just hiding in there, and ever so often I put my nose out, and all of this activity is happening in this room, throughout the whole building. And I can't tell you how exciting it is to have that kind of animation, and this kind of thinking, and these kind of ideas, rocketing around and shaking us up quite a bit. So thank you enormously for helping a mole through the day and animating this building so terrifically, and very good luck for the rest of your conference.
Okay, good afternoon everyone. I don't normally have a microphone, but for any of you who can't hear me, please just do wave. So welcome to our second session, where we're looking at disability, dance and the legal rights framework, looking at support structures for disabled dancers. Just want to start by unpicking that slightly, because there will be a lot in the title. First, we're looking at legal rights. Charlotte said this is really, really exciting, honestly. But also it has the precursor legal rights, because I think we have to question as lawyers, legal rights are not necessarily the same as what other people might think rights should be. And we will be looking at that in some detail today. We've also stated several types of the laws that we're going to be looking at. We're looking at human rights, copyright, medical law, and disability law. And again, that's very important because, as you may know from your careers, from your personal lives, there are many, many different types of laws. And one of my personal obsessions is that laws don't speak to each other nearly enough. And even sometimes before they speak to each other, sometimes they just say the wrong things. Or they don't even address the particular issue. Sometimes they might seem to be helpful, but they just aren't developed enough. And I think a couple of points I don't think my colleagues are going to pick up on, but of perhaps parallel interest. We are seeing some clashes, for example, human rights to freedom of expression. In some cases, we're seeing that as prevailing over copyright. So we're seeing perhaps a more community or a more cultural focused right prevailing over that particular property and commodity-based rights. We've also seen at international level and also within UK legislation, revisions to copyright law to take into account visual impairments, and at the UK level to take into account adaptations to a work to take into account other types of disabilities. So there are some steps, but there's not nearly enough. And these take place within a legal vacuum, quite removed from real life people, and certainly quite removed from dance. And that's really the focus on our discussions today. So, it's my great privilege to introduce you to what we're looking at the support structures. What do we mean by support? Is this help? Is this rather paternalistic? Is this rather judgmental? Or does it mean what other people have decided that you might need? And again, kind of will be exploring different elements of that. So, my name is Abby Brown, and I'm a senior lecturer at Aberdeen, and I look mainly at innovation and creativity laws and as they intersect with other legal fields, and particularly human rights. My panel, first of all, I have David Cardinal, and he is from University of Stirling with a focus on disability laws with an interest in sport. And I have Luke Powell, who is a dancer and a curation. I have Sean Harman from the University of Edinburgh with a focus on bioethics, medical law and dignity. Colette Conroy from the University of Hull with an interest in theatre and performance studies and cultural and disability studies. And Mathilde Pavis from the University of Exeter with a focus on copyright. Now I'm going to ask each of my panel to speak for about 10 minutes on the same issue. I have no doubt that we will not get the same answer. The question is, what does it mean from each of their disciplines to support the disabled dancer? And how is this actually done, if indeed it is done at all? We're going to speak in the following order. which we've given lots of thought to, and I hope this will intertwine lots of different perspectives and stimulate our thinking and your thinking. So we'll have Dave, then Colette, then Mathilde, then Sean, and then Luke. After that, the floor is very, very much open. I will try and lead our discussions of conflict and theme and solution, but really we are very much in your hands and we very much look forward to what you have to say. So please, Dave.
Thank you very much. It's nice to see the Scottish Mafia without needing this passport. So this feels really strange. There are several things that one shouldn't do just wearing one's socks. This is very much up towards the top end of things not to do while wearing one's socks. Very strange indeed. I'm always far more interested to hear what the people have got to say because I know my own stuff so well and I'm a bit bored with it sometimes. And I think what these ladies and gentlemen are going to introduce you to is going to be very stimulating and very exciting, certainly for me. And I'm looking forward to hearing you. And also, let's say, how much I enjoyed those presentations this morning. It's a tough act to follow. Before I defer to what will doubtless be the more interesting contributions from my chums behind me, what I'd like to do is introduce you to the general legal framework that deals with disability discrimination generally. And obviously I'll try and give it a dance-related focus. And in particular I'd like to talk a bit about the interface. See, I'm a lawyer, I use words like interface, throw that one in there, between United Kingdom domestic law, which we now find predominantly in legislation called the Equality Act of 2010, and key global legal provisions. And there's two key global legal provisions, one of which I'll talk to more than the other, and they are the European Convention on Human Rights. And I can call that a global provision because virtually everywhere else in the globe has a reflective document, but also the United Nations Convention on the Rights of Persons with Disabilities. And that's the one that I'll, with your leave, focus on a little bit more. The Convention focuses on many things. Amongst the many things it looks at is the issue of participation and the issue of access. And both participation and access are broadly defined. And it looks at issues of participation and access not solely in the context of dance, obviously, nor solely in the context of wider forms of physical culture. Well, there is a specific provision within the Convention that does deal with dance, sport, the arts, music, physical culture, broadly defined. And it's a very dynamic instrument. You can use it in lots of ways, creatively, that maybe the drafters of the domestic legislation didn't really think about when they created UK domestic law that sits side by side with it. The United Kingdom, being a signatory to the Convention, along with the European Union and a host of other countries worldwide, does have to take Convention rights into account when it is interpreting its own domestic legal provisions. So it's not simply a question of us looking at the 2010 Act of Parliament and saying, well, these are the rights, the body of rights that the Equalities Act gives us. We need to look at that piece of legislation in addition to looking at the Convention, the European Convention on Human Rights as well. And so far as is possible, domestic law has to be interpreted in a way that is consistent with both the Convention on Disabilities and the European Convention on Human Rights. Okay, so lawyers, judge makers, lawmakers in particular, the judges, have to think very flexibly sometimes, very creatively. How do we give effect to these international global treaties that we've signed up to without stretching the language of the law that Parliament has passed so much that we stretch the language of the law beyond breaking point? And that's a tension that we often see in human rights law broadly. And I'll give you, for instance, It is contrary to the Convention on Disabilities to lump people together on the basis that they have a particular, quote from one of the judgments, intellectual or mental disability. The Convention says, no, you do not put people together as being members of a class. You know, wheelchair users, people with spinal bifida, mental health issues, whatever it may be. You treat the individual as the individual. Fundamental prerequisite of the Disabilities Convention. Problem there is that that ain't what UK law historically has said. It has classified people into particular groups and dealt with that group as a group rather than individuals. For people like Hannah and I who are interested in that interface between sport and disability, that actually creates major challenges because disability sport, the Paralympics, only works if you lump people together. The class 43 wheelchair users. Can you imagine another walk of life where we talk about people in wheelchairs and oh, you're class 43, and he's class 41. But you take that away from the sporting environment and you don't have a Paralympics anymore. Good or bad thing? Well, I suppose that's a matter of personal philosophy. Convention acknowledges that disability is an evolving concept, and what we regarded as being a disability or the disabled 20 years ago is no longer tenable. Law can be dynamic, convention rights in particular can be dynamic. And the beauty of that is it does allow you to push at the boundaries. Yes, we might have this judgment from 2008, which tells us what it means to have a disability. Give it 10 years, the course may well turn around and say, well, that was then, this is now, times have moved on, and we have to reflect the fact that the convention in particular obliges us to take that dynamism into account. It causes another difficulty with domestic law because the convention speaks to an avowedly social model of disability, where it is not the disabled individual that is, quote, the problem. It is the barriers that wider society puts in the way. There's going to be psychological, attitudinal, just as much as physical barriers. The barriers that societies put in the way to full and equal participation, and I'm putting equal in inverted commas there. Problem is that on the one hand, the convention is accepting that avowedly social model and explicitly rejecting a medical model of disability. Guess what? Lo and behold, UK domestic law does it precisely the other way around. So it reverts back to a medicalised model of disability that really has its roots in the 1960s. It's not as bad as it was. We can still see those traces of the old law coming through what domestic legislation does. Now, if UK law was all we had to go, we didn't have to worry about pesky things like the European Convention on Human Rights and Convention of Disabilities. You would look at the wording of the legislation and say, well, that's it. We are limited to being able to do that which domestic UK law allows us to do. Happily, we is not in that position. We can look at domestic law on one hand and convention rights on the other. And it's, if you like, it's a form of combination therapy. You use the more liberal possibilities of the European Convention and the Disabilities Convention to give some impetus to this very narrowly framed domestic legislation that recent history has wondered us with. Now, because all these provisions are dynamic, as the Convention itself explicitly says, when we signed up to the Convention on Disabilities, we being the state, signed up to the Convention on Disabilities and also the European Convention on Human Rights, you simply don't know how things are going to pan out 10, 15, 20 years down the line. Okay, that's the beauty of it. Rather than being hamstrung by what the law says, you can actually use it in a very creative manner to push the boundaries of what we think is normal, acceptable, appropriate, and all those other value-laden terms that we should avoid as much as possible. But all this comes with a health warning. Once you start engaging with the invoking the services of my learned friends, you are pretty much acknowledging that your working relationship with the other side is at an end. There's no going back. It's not, shake hands, kiss on the cheek, let's meet for dinner sometime, that's it. That's an end to it. Anything else is the exception that proves the general rule. So you've got to be willing to let that relationship go in order to build something better some stage down the line. Okay, think very carefully. Okay, act in haste, repent at leisure. Be very, very careful indeed before you go down the formal legal route. Use it as a means of cajoling, persuading, having the arguments over a beer. But please be very careful before you flounce off and say, well, I'm going to go and talk to my boss. It's as much of a problem, it's more of a problem than it is a solution. Domestic legislation has to be our starting point. Okay, we think about what that says and then we try and use convention rights to build onto that. A domestic law 2010 Act says that a person, quote, has a disability if they have, quote, a physical or mental impairment, see that mental model kicking in again, which has, quote, a substantial and long-term effect on one's ability to carry out, quote, normal day-to-day activities. If we were limited to doing what domestic law allowed us to do, well, we pretty much be stuck there before we even started. Because you have to get over all those hurdles before you can even think about, well, what does the law say? What remedies might be available to us? We can spend a long time, and some of us frequently do, talking about what we mean by impairment, substantial, long-term, normal, day-to-day. None of these values are fixed. They're all up for argument, they're all up for persuasion. They're all inviting you to use law creatively and to think, well, okay, maybe that's what it would have meant 20 years ago, but we can push the boundaries a little bit more. Yeah. I think one of the beauties of having a group like, I don't want to use the word clique, but bear with me, I'm going to because I'm running out of time. Having a small group of people who are all alike mind and get why this is important is actually more important than thinking too much about what the legal remedies might be. If you've got people on site, it's a lot better than just to say, oh, by the way, do you know what the convention says in terms of access to building and coaching and employment and all the rest of it? Use it in a persuasive way, rather than barrel-arsing you and say, well, I am going to talk to my lawyers because the law says that I have rights and you're not doing it. It's a very dangerous game indeed when you start talking about what the rights are that the law gives you. I will finish by flagging one very important point. You cannot justify distinctions, cannot justify discrimination and treatment on the ground of somebody's disability, however disability or treatment, etc., might be defined. The only exception to that, the only defence there is to a difference in treatment, is where the burden of, quote, putting it right would be excessive, unduly burdensome. That's where the lawyers make them. What do we mean by excessive? What do we mean by unduly burdensome? It's going to be really interesting to hear what other people say about how some of these legal issues work out in practice. Please, the take-home message has to be, do think long and hard and very carefully before you invite the lawyers to make those distinctions for you, to make those definitions for you. It's a lot better working with people than trying to work against them, like fighting the proxy war, using the lawyers on your behalf. So I'm going to leave it there and hand over to you.
Thank you, so I think that's been a really insightful overview of what the law says. That, funny enough, the law isn't clear, but both it provides some potential for where we can take it, but of the real obstacles. Changing the laws, we might move towards calling for new laws if we can't perhaps bring the groundswell of the community with us. That's going to perhaps have more limited practical effect. But then I'm a lawyer, I think these things are important. Correct. In the real world, do people think these things are at all important?
disabled performers from the perspective of my discipline of theatre and performance studies. I thought that it was a way of looking at questions of audience and questions of reception, which of course can't be legislated for. They're very difficult to talk about also. So I'm going to use one particular framework which may or may not work for you. Please feel free to challenge anything that I say, because I'm just trying out a couple of ideas. If you think about any aspect of performance, feeding back a bit, in the context of inclusion and exclusion, you see a very complex web of recognition and misrecognition. That's what I'm going to talk about, audience responses, recognition and misrecognition. Ideas about misrecognition and hurt are at the centre of my thinking at the moment. I've been returning to the notion of misrecognition, which is a three-part structure of love, esteem and respect, that which we cannot not want. Thinking about the capacity of theatre, drama and performance to help to achieve this. Many of us here in the room acknowledge, or at least have a faith in the idea that disabled performance offers a chance to make changes to the political recognition of disabled people. And in my view, and this is part of a longer discussion, it does this partly by nudging, shifting the aesthetic norms of our lived social world. But I think that this is not without cost to the individual performer. And that's what I want to talk about now. So all areas of cultural activity, to some extent, reflect and replicate the structures that exclude, even when they're doing their best to undo this exclusion. Give you an example. Debates about quality and professionalism, training and education have as their base a belief in aesthetic values, skills, and in cultures of reception which have grown and developed as the cultural tools of the regime of art that we might wish to challenge or to resist. The model of inclusion requires, it might be said, the excluded individual group to adopt aspects of this exclusive culture. So, for example, we see a lot of anxiety about the quality of disability work or its professionalism. And in my view, this anxiety about quality gets disproportionately high levels of discussion, reflecting our insecurity about working within a disabling institutional framework with bodies that are not properly recognised as performing bodies. And I think it's part of my discipline's job to help to put this in place. I think we should have more ambition in this respect. Many activists and cultural critics, as well as many artists, are adamant that we should maintain the freedom to say, this is bad work, this is good work. And the logic suggests that the court of public opinion must be free to make up its mind and to respond with a verdict of whether the work is good or not. The professional disabled performer does not want allowances to be made. This is the logic of it. They don't want to be patronised, they don't want audiences to say, that's good amateur or community work. They want it to be seen through a similar sort of frame. We're ready for harsh criticism, they say. We're professionals. And on one level, that's okay. When I started to work for Grey, I did 20 years ago, disabled performers were still really anxious that they were being perceived as community performers, as people participating in the arts as a form of therapy. And in that context, their willingness to have their work judged in a good, bad sort of way made sense. But things have changed since the 1990s. Disability performance can help to develop a more interesting and nuanced culture of reception. And really, when it comes down to watching a performance, a spectator who leaves with the judgment, this is good, or this is bad, has a very impoverished view of the performance. They're not very interested, or possibly not very interesting spectators in that sense. So I think we also need to be more ambitious for the audiences as well, for the spectators. One of my ongoing struggles is with the implications of some of the achievements of access aesthetics and the achievements of notions of participation. Does it matter for the groups of young people that I work with that there are professional disabled performers? The young people have no more chance of working for Grey Eye than they have of working for the RSC. It's not all to do with talent. It is also to do with class, education, even type of impairment, etc. What's the importance of the professional disabled performer to me? Why does it matter to me that there are disabled people appearing in the world of art and representation? I don't just have an interest in similitude. I'm not that narcissistic. I'm not asking disabled performers to be there to represent me. I'm asking them, and this is a big thing to ask, to stretch the boundaries of spectatorship, to nudge our spectatorial responses to the point where audiences see the skill, the intention, the beauty in all sorts of different performances. And these will sometimes clash with the institutional frames of theatre and performance. Two further frames. So these frames get in the way here. The frame of professional performance quality, which I've already talked about, and the multiply overwritten frame of disability. So I've talked at the beginning about recognition. Recognition is an interpersonal regime of political articulation. You can be recognised as a disabled person. You can also be misrecognised as a disabled person. So to give an example, here's an example. It cites the laws. I wish it was broadly relevant. So forgive me if this is a bit much, but I'm going to read out loud a letter to some friends of mine. Quoting now. I saw your production in the company of someone who was furious when she discovered that the cast were almost all people with learning disabilities. She had paid £24 and she's finding it hard to make ends meet. Cut a bit there. We were handed your questionnaire on the performance, but noted that it avoided the key question whether we were unhappy in any way with the fact that we had not been told in advance about the cast. Since that evening, I've asked quite a few people what they thought of this non-declaration movie cast. I also asked my fellow students on a philosophy course philosophy course I was attending. Excuse me, I couldn't think where I zoomed in there at the time. Sorry to interrupt the prose flow. Everyone who responded said that it was in some way or other misleading / wrong, not to say that the cast was one with special problems. Words used included unfair, counterproductive, inappropriate, unacceptable, dishonest, and even that it could possibly be considered a matter for training standards. That's one for the lawyers. The writer goes on to say, one of my child is fine, and I once worked with children, mental hospital, blah, blah, blah. And I'm therefore interested to know what are the reactions you received from people who did not know in advance the particular character of the cast in this production. Now, the writer of this letter has failed to enjoy the performance, or even to see the performance, because he or she can't engage aesthetically with the notion of disability performance, or the performance work or artwork of disabled people. What she or he says is obviously, on some level, hurtful, possibly comic, but also hurtful. On the other hand, the performance, the company, in this case, writers have deliberately chosen not to identify themselves as disabled performers, because as one company member expressed it, a quote, if we say we're disabled, they'll think we're crap. And there is, understandably, a concern that disability gets in the way of seeing and responding. It's a frame that pre-exists the encounter, and it drags all sorts of values and ideas along with it. So there's a double misrecognition at play here. The frame of disability is problematic to audience member and to performer. They understand the frame, but in this example, the performers understand that disability and performance don't fit easily together, and they are kind of anticipating this in the way they frame the work. It has an injurious effect on them. It is something that helps them to structure their work in a potentially problematic way. They play out and experience the expectation that they will be misrecognised, that the audience will see not their art, not their identities as creative and skillful individuals, but that they will see a cultural trope that's problematic, denigrated, excluded. The performer in this context, 1 minute, and also in the ongoing anxieties about quality, can become used to anticipating misrecognition, carrying it with them into encounters with the audience. The spectators are complex, sophisticated entities, and so single and unitary notions of spectatorship aren't easy to sustain. Disability may be a way of opening out responses, but it's also a way of closing them down. The process of anticipating responses is a difficult thing to deal with, and it's part of the world of disabled performers. They can't change this on their own. It's difficult to contribute to culture and also to negotiate the frame of reference and response at the same time. It's just too much for an individual performer, artist to take on. Not to say that some people don't do it. I know I'm in the room with some people who actively engage in both of those frames in a very distinguished way. But partly it is our job as people working possibly in academic theatre and performance studies, the job of writers, critics, audiences, to strengthen and open out the quality of response to disability performance, highlight the originality and creativity of disability performance, and to model responses that extend vocabularies of response beyond good, bad, professional, non-professional, disabled, non-disabled, and I'll finish there. Thank you.